Hello friends, my name is Nizamuddin Ahmed Siddiqui and I am an assistant professor of law at West Bengal National University of Juridical Sciences, Kolkata. I will be taking this unit on the growth and expansion of environmental rights in India on behalf of the content writer Dr. K. Sita Manikayam, assistant professor Dr. B.R. Ambedkar Law College, Andhra University. This unit aims to fulfill the following learning objectives. Number 1, learning about the essence of environmental rights and duties. Number 2, understanding the obligation of states in protecting the environment. Number 3, to understand the role of judiciary in the emergence of environmental jurisprudence in India. With these objectives, let us start our discussion. The Constitution of India is a living document which has developed in both time and space. The provisions in the Constitution which talk about the protection of environment are consequential to this developing nature of the mother document, where the preamble to the Constitution guarantees for the preservation of the dignity of the individual. It also takes account of the socialist model of the society. It therefore seems that the idea of a living and pollution-free environment emerges from this consequentialist approach. The Constitution of India obligates the state as well as the citizens to protect and improve natural environment. The concern for environmental protection emerges at two levels. First, at the level of the law of the land itself. For instance, through the Environment Protection Act 1986. And second, as an emergent fundamental right which obligates the state to provide clean and pollution-free environment to every individual. The idea of a pollution-free environment therefore is wedded to human life when it is expected to be experienced in its full dignity. Let us examine the constitutional framework for the protection of environment as it has developed over time in India. Articles 14, 19 and 21 of the Constitution deal with the right to equality, freedom of speech and expression, and the right to life and personal liberty in that order. All these rights are protected as valid and enforceable entitlements in favor of the citizen to be enforceable against the state. For instance, Article 14 of the Constitution states that the state shall not reject any person equality before the law or equal protection of law within the territory of India. A valid question which arises therefore is whether Article 14 can be violated in a manner so as to violate environmental concerns in a state. It is observed that Article 14, right to equality, is violated whenever governmental decisions fall in favor of any party and the subject matter directly or indirectly happens to be an environmental issue. Whenever the licenses or permissions are granted by the government in an arbitrary manner for the construction in projects which are in contravention to development regulations, it can be construed as a violation of the environmental interests. Similarly, where mining permissions are granted to people with inadequate or invalid approval of the relevant authorities, there might ensue penalties for causing damage to the environment. In many cases, environmental activists have resorted to taking legal proceedings under Article 14 to defy the constitutional validity of such rules and orders passed by the government. However, the scope of Article 14 is not limited to interpretations through the aforementioned method. Article 14, 19 and 21 of the Constitution have now been regarded as constituting the golden triangle of the Indian Constitution. Courts have pronounced numerous judgments to create interlinkages between the aforementioned articles. Let us examine this relationship from the perspective of Article 21, that is, cases in which Article 21 was the main issue at hand and the court stepped further to link it with other fundamental rights under Article 14 and 19. In the celebrated case of Maneka Gandhi versus Union of India, the Supreme Court added a new scope to the idea of personal liberty of an individual by linking it with the objective of equality. The court laid down that any rule or law affecting life and liberty of a person must stand the analysis of Articles 14 and 19 of the Constitution. In other words, if a law is enacted by a legislature which affects the life and liberty of a person or restrains it, then it is a mandatory prerequisite that the procedure recognized by such rule to limit the liberty of a person be reasonable, fair, and just. At the first instance, the path which the court has taken does not seem to have any implication over the environmental concerns. However, on a closer look, it becomes clear that it is this explanation of Article 21 which the court has utilized to incorporate the right to a healthy environment. In rural litigation and entitlement Kendra versus State of Uttar Pradesh, also known as the Dehradun quarrying case, the Supreme Court considered complaints which alleged that the operations of limestone quarries in the Mussoorie-Dehradun area were resulting in the deprivation of the natural environment, thereby affecting the ecosystem of the area. Moving under Article 32 of the Constitution, which allows the superior courts to issue writs in the nature of orders facilitating the enjoyment of fundamental rights, the court ordered the closure of some of these quarries. It was held that these quarries were disturbing the ecological stability of the environment. Though the judgment did not make a direct reference to Article 21, it nevertheless discussed the infringement of right to life under Article 21 by attracting the jurisdiction under Article 32 of the Indian Constitution. Friends, let us now discuss the directive principles of state policy and the way they ensure environmental protection. The directive principles of state policy contained in Part 4 of the Constitution set out the aims and objectives to be taken up by the states in the governance of the country. The directive principles under the Indian Constitution is directed towards ideals of being a welfare state. These principles lay down certain economic and social policies, thereby putting an obligation on the state to take positive action to promote and protect a healthy environment, and therefore to promote the welfare of the people. Article 37 declares that the directive principles contained in Part 4 of the Constitution are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Similarly, Article 39B of the Constitution provides that the state shall direct its policy to see that the ownership and control of the material resources of the community are so distributed in a manner that best serves the common good. The term material resources of the community are taken to embrace all things which can produce wealth for the community, and are taken to include such resources which are in the hands of the private persons. It therefore is not merely limited to only those resources which are already vested with the state. Further, Article 47 provides that the state shall regard the raising of the level of nutrition and the level of living of its people and the improvement of public health as among its primary duties. The Supreme Court in Municipal Council Ratlam versus Vardhichand observed, the state will realize that Article 47 makes it a paramount principle of governance, and that steps are taken for the improvement of public health as amongst its primary duties. It therefore needs to be emphasized that the improvement of public health also includes the protection and improvement of environment, without which, of course, public health cannot be assured. An individual is never a product of his own choices. He is supported and nourished without doubt in his personality by his environment, of which natural environment plays the biggest role. Similarly, Article 48 deals with the organization of agriculture and animal husbandry. It directs the state to take steps to organize agriculture and animal husbandry on modern and scientific lines by providing methods and means for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. The state is also required under Article 49 to protect every monument or place or object of artistic or historic interest, which is declared by or under law made by the Parliament as such to be of national importance, from spoliation, disfigurement, destruction and removal, among a number of things. Further, Article 51 provides that the state should strive to foster respect for international law and treaty obligations. It is therefore incumbent upon any state, including India, to give proper concern to the international obligations. For instance, recently India has showed its intention to be bound by the Paris Agreement on climate change. Keeping other concerns in mind, Article 51, read with other existing legal obligations under domestic and international laws, would obligate the state to take necessary measures to fulfill the promises which it has made. Article 48A is one article which makes a direct reference to the environmental concerns. It says that the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. The Madras High Court in M.K. Janardhanam versus District Collector Thiruvallur observed that the phrase used in Articles 48A and 51A is protect and improve, and that the phrase appears to contemplate affirmative governmental action to improve the quality of the environment, and not just to preserve the environment in its degraded form. It is quite well understood that the Constitution places a fundamental duty on every citizen to protect and improve the natural environment. Article 51AG of the Constitution of India creates a related duty of every citizen to protect and improve the natural environment, together with forests, lakes, rivers, and wildlife. It is therefore necessary to understand that the provisions of the Constitution highlight the importance of environmental protection and improvement and lay the foundation for the emergence of a highly specialized jurisprudence catering to its best the environmental concerns. Let us take another example. Rajasthan High Court in Vijay Singh Punia versus State of Rajasthan observed that any person who disturbs the ecological balance or degrades, pollutes and tinkers with the gifts of the nature such as air, water, river, sea and other elements of the nature would be understood to not only violate fundamental rights guaranteed under Article 21 of the Constitution, but would also be seen as breaching the fundamental duty to protect the environment under Article 51AG. This highly relevant observation came up in a writ petition filed against dyeing and printing units, which were discharging effluents, thereby polluting the water sources used for agricultural and drinking purposes. It would not be worthwhile to state that the Supreme Court of India has put in commendable efforts in expanding the contents and contours of some of the basic rights by linking them with environmental concerns. In this process, Article 32 and 226, which provide a right to constitutional remedies to the citizens before the Supreme Court and the High Court, have become quite handy. The Indian court reading of Article 48A into Article 21 of the Constitution has brought out a revolutionizing interpretation with regards to the right to life in a healthy environment as part of life and personal liberty of the people. There are some other interesting developments which quite interestingly also fall within the domain of international environmental law. In Indian Council for Enviro-Legal Action versus the Union of India, the court recognized and upheld the polluter pays principle as a part of environmental law of the country. Similarly, in a different yet equally relevant Vellore Citizens Welfare Forum versus Union of India case, the court alluded to the precautionary principle as a well-recognized principle in international environmental law. Interestingly, the Supreme Court referred the Brundtland Commission report and other international documents in addition to Articles 21, 48A and 51AG of the Constitution as already discussed. It also took into account the legislative mandate to protect and improve the environment as found in enactments like the Water Prevention and Control of Pollution Act 1974, the Air Prevention and Control of Pollution Act 1981 and the Environment Protection Act 1986. Friends, in conclusion, we can therefore say that the Constitution of India embodies the framework for the protection and preservation of nature, without which life cannot be enjoyed to its fullest. However, in India, most of the environmental jurisprudence has developed through the writ jurisdiction of the courts. Hence, under judicial activism and public interest litigation, it is the Supreme Court and the High Courts that have brought a mutational change in the legal system of the country. The gradual expansion in procession jurisprudence has played an essential role in developing and providing impetus to environmental jurisprudence, thereby connecting it with human rights. Friends, I thank you all for listening to this lecture with patience.